SJC-12495, Commonwealth v. Richard Gardner.
Ms. McKenna, good morning.
Good morning. If it please the court, Gail McKenna, Assistant District Attorney for the Commonwealth. Here today with me is Shannon Buckingham, who is my indispensable trial and motion attorney in this case. The question before the court today is whether or not the judge erred in dismissing this case by adding the word Massachusetts to the statute in order to narrow it under the court's narrowing jurisprudence, which led him to believe that every time someone's prospective eligibility is challenged for treatment in this case is challenged, that his option was that he needed to do whatever needed to be done to narrow the statute, which here included adding the word Massachusetts when we had an individual here who was clearly a prisoner in a correctional institution and eligible for us to file a petition for treatment and rehabilitation under the statute.
It applies to everybody who's here on the joint compact?
Well, I would say if another state determines that they want someone to be sent here, that yes, we could file against that person because they are a prisoner under the statute. And remember, what we're talking about here is eligibility for treatment and rehabilitation, which is what the purpose of this, one of the purposes of this statute is. And the compact specifically says that whatever benefits accrue to prisoners in the receiving state also accrue to persons.
I find it hard to believe that Mr. Gardner is going to see this as a benefit.
You could ask him.
I don't think it's from his perspective necessarily. But what I would say is that what this court has done to this statute, which has passed muster under the substantive due process analysis, that it's sufficiently narrow under the analysis of how the procedures are in place in order to analyze whether or not somebody is being considered under the liberty interest to be held, is narrowed eligibility. And eligibility, when we're talking about a remedial statute that's offering mental health treatment, albeit the liberty interest is still strong. We do this under 123, we do it for Rogers orders, we do it in a variety of different circumstances.
And so in those cases, you're suggesting that you could bring a prisoner in from another state for the purposes of a Rogers hearing or a 123 proceeding?
No, and we haven't done that here. We did not bring someone in from another state. Rhode Island transferred him here. And
so Rhode Island could transfer somebody for the purpose of a 123 or a Rogers hearing?
Well, if Rhode Island is transferring someone under the interstate agreement, we have to give that full faith and credit.
Right. Now, how did that interstate agreement get started, applied in this case? How did it get implemented? Who started this?
Well, who started it? Massachusetts, obviously, we were interested in having him back. That's no secret. There's nothing nefarious about that. But this is Rhode Island's decision that we have to give full faith and credit to.
When you say Massachusetts wanted him back, Massachusetts wanted him back to commence these proceedings.
For treatment and rehabilitation. Right. Because he's a Massachusetts resident, and his agreement was that he was going to be released on parole once again in Norfolk County.
Okay, but
so we had an interest in him, an abiding interest in him. That's no secret.
Right.
But at the end of the day, I can stand at the border and say, Red Rover, said Gardner right over. There's nothing Massachusetts can do. The only way he comes here is if Rhode Island sends him.
So if he serves his time in Rhode Island, we're not here, obviously. He's not a prisoner in Massachusetts.
We did explore ways to do that, and I don't believe that there's a way that we can reach into Rhode Island and grab him. But here he is in Massachusetts, and he squarely fits within the eligibility criteria, which the legislature, within its wisdom, has said we want to rehabilitate and we want to treat people. We also
What
want
does the
to,
compact say about what happens to someone, what the receiving state can do?
well, the receiving state is not limited in the way that it can, there's nothing in it that talks about whether or not we can file a petition or whatnot. I mean, that just simply isn't part of it, but we do have to treat every prisoner the same way that we treat anybody else who's here as a quote-unquote Massachusetts prisoner. So for all intents and purposes, he's in the custody of the...
And I should know this, but I don't. Does the defendant have any say in the transfer?
One of the problems we have is that we don't have a full record of what happened in Rhode Island. And remember, we're giving full faith and credit to what Rhode Island did here. What we do know is that they had a hearing, that there was a decision, that it took 30 days to transfer him, that there was no appeal and no challenge in Rhode Island to the Rhode Island procedures. He came over here.
So we don't. So if someone's in Utah and they end up in Massachusetts, your view is, well, we got him. He's gonna. We can file on him, right?
No, I mean, I think the other piece here is that he was a Massachusetts resident and he was going to be released in Massachusetts. You know, I think part of what the compact says is that...
But you argue that we can file on anybody who's a Massachusetts prisoner.
Correct.
Right. So if someone from Utah becomes a Massachusetts prisoner, say they're here because there's some safety concerns,
Sure.
which happens. If we adopt your view, can you file on the person from Utah because they're a Massachusetts prisoner?
So long as at the end, when he's released from the treatment center, we do send him back to
All
Utah.
right, when he's 90 years old.
Sure.
Okay.
And
Right.
what about going back to Justice Cypher's question? So the defendant comes here under the compact, and they're held in Rhode Island on the functional equivalent of a Chapter 123, Section 7 or 8, for mental health reasons and danger in Rhode Island. Even though we have Commonwealth versus Gillis, where we have held that the defendant would not be a prisoner for the purposes of Chapter 123A, your view is if they came here under the compact, they'd be a prisoner.
I don't know how he could come here under the compact under a civil commitment in Rhode Island if they have such a thing. It's unclear whether Gillis is still good law because Gillis pertained to the Bridgewater State Hospital, which is no longer a piece of the Department of Correction. However, even in defining prisoner there under the 3 dictionary definitions, Gardner fits squarely within those definitions.
What do you say about, say Chapter 125 does apply to the definition of prisoner for the purposes of 123A, Section 12. The Chapter 125, by definition, refers to correctional institutions in the Commonwealth.
Right.
So wouldn't that limit prisoner to prisoners sentenced in the Commonwealth?
No, it's a person who's physically in a correction institution in the Commonwealth. And I would also direct the court's attention to the amendment that to the statute after the Alley-Zapp case that says, whoever has been convicted or adjudicated, regardless of the reason for current incarceration, confinement, or commitment, fits within the statute. And what we're talking about here is eligibility criteria for rehabilitation and treatment. And so the legislature defined that in a broader sense in order to encompass on this public welfare statute as many people as possible. And that was reasonable. And we have a statute here that has survived substantive due process review again and again. And this court said in Blake, when we're looking at that kind of a statute, we look at whether or not there's fairness here. And it's perfectly fair for the legislature to say, we want to include as many people as possible for this remedial purpose. But if we are including them, we're going to subject the petition to the very strict requirements, procedural due process requirements, the time limits, and so on. And what the court also said in Blake is, we know the legislature is aware of the liberty interest because they set up those very strict time limits. So every time the court in the Superior Court too, in believing that they have to narrow the statute at all costs, does that. They're preventing someone who requires mental health treatment from getting mental health treatment, from getting rehabilitation, or the possibility of it, because let's face it too, the mere fact that a petition might be filed doesn't mean that someone is going to be detained for the rest of their life. There's a whole bunch of other steps that have to happen before that ever happens. We're only talking here about eligibility criteria and whether or not it's appropriate, despite the words of the statute and the intent of the legislature.
Counsel, was there anything stopping the Commonwealth from filing a petition while the defendant was actually serving a Massachusetts sentence?
Well, Your Honor, there's some hearsay in the record about the fact that there was human error in that. However, under Bruno, we know that we can file at any time because the question is always going to be, when the petition is actually examined, what is the current mental state of the individual? And we know here that we didn't file, but had Gardner never reoffended under Rhode Island law, or had Gardner gone on to live his life in a non-dangerous way, let's say, he never would have come to our attention again. But he didn't. What he did was he violated his Rhode Island probation while here in Massachusetts. Rhode Island took him back, and then under the interstate compact, Rhode Island sent him back here because he was going to be released to probation again here in Massachusetts. So those are all of the circumstances, and of course we could file again. We can file anytime someone meets the eligibility criteria.
But you said before, in answer to Justice Gaziano's question, you could file on somebody who was coming from Utah, regardless of whether he was a Massachusetts resident and regardless of whether he's going to be released into Massachusetts. So are you just talking about what the discretionary, when you would actually do it, and the discretion the Commonwealth would use is if the person was being paroled into Massachusetts and was a Massachusetts resident?
Well, in the particular circumstances of this case, I only need to go that far. I was answering a hypothetical posed by Justice Gaziano. I do believe that we could, but that's probably something, a next step that this court would want to review.
Can you tell me, how would this work from within the state, from county to county? For example, if we have a defendant serving a sentence from a crime that was committed in Suffolk County, and he's going to be released from Suffolk County, but could the Bristol County or Plymouth County District Attorney's Office file an SDP petition?
The statute allows the petition to be filed where the person is being released or where the crime was committed. So there's no bar there. The Suffolk District Attorney can file in Suffolk if the person's serving the sentence in Suffolk. The Bristol District Attorney can file on the person serving in Suffolk if the crime happened in Bristol.
So they would arguably have been transferred from the House of Correction in Bristol or Cedar Junction to somewhere in another county, is that? So it'd be the same basic idea?
Right, and again, you see that the legislature set that broad criteria for eligibility, and in using the word broad here, I don't mean to in any way suggest that there's a violation here of substantive due process by making as many people as possible eligible for what is a public welfare statute here. It's in that section. There's obviously a public safety issue here involved, and there's liberty interests, but we know from our past case law, like Burke, that we know that the legislature considered those things, and the legislature can consider those things while also opening this statute up to as many potential individuals who may be eligible for treatment and rehabilitation. And I see the...
No, I've got some questions for you.
Excellent.
You agree that he remains a Rhode Island prisoner, even though he's physically in Massachusetts under the compact?
I don't, Your Honor. I believe
Really?
he is both. He is
Under the compact, is it not clear that even when you are sent to a different state, you remain a prisoner of the sending state?
He's under the words of the compact, he's under the jurisdiction of Rhode Island, but under our statute, which also applies, he is a prisoner here in the Commonwealth.
But wait, that statute that you're talking about, which one is that?
That's 123A.
120, but
And
what
it's
about,
also 125.
and so 125
one.
refers to people brought here through the compact?
It refers to anybody who is in custody here in Massachusetts. It's the general definition, and even under what is now dicta in Gillis, which are the 3 dictionary definitions, he's still a prisoner here in Massachusetts. It's not as though he comes over here to Massachusetts and he's in the custody of the Department of Correction, and we're just going to let him walk out the door because he's no longer a prisoner. He's under the jurisdiction of Rhode Island, but he is a Massachusetts prisoner.
And do you agree that the interstate compact says that the prisoner must be returned to the sender state for release unless criminal charges are pending in the receiving state?
I don't agree.
Okay, is it not in the, what does the compact say with regard to that
The
issue?
compact also allows for the agreement, and here we had the agreement of Mr. Gardner that he was going to be released into Massachusetts. So he wasn't going back to Rhode Island, he was being released to Massachusetts. But even if he wasn't, at the end of the day, say the hypothetical where he came from Utah, at the end of the day, we will gladly return him to Utah. So all of the concerns of the compact, and the concern of the compact is prisoner dumping, that say we send somebody to California, and that's how we move all of our prisoners out and we don't take them back. So that concern is alleviated because he is still under, we would still comply with that.
So how does prisoner dumping become avoided in these circumstances? Literally, what happens?
Well, he's, at the end of the time, he's returned to the sending state.
And who returns him?
Massachusetts.
And do they return him before the sentence is absolutely finished, so that it's the final day, or do they return him the day after?
At the end of his commitment.
Right, so your view is
After.
it's the end of a life and a day.
But here he's, correct. But here that never happens, because what we have is the agreement to be released to Massachusetts. So as I said, that's entirely a hypothetical that isn't raised on the facts of this case.
Now, the compact also provides that that the transfer to the receiving state cannot deprive him of rights he would enjoy in the sending state, correct?
It does.
Okay, and if he were released in the sending state, that is Rhode Island, you would not be able to civilly commit him under our SDP law. Do you agree with that?
Yes.
So does that
However,
not deprive him of a right that he would enjoy had he been in Rhode Island? That is the right to walk out of the prison a free man, subject to parole, as opposed to being civilly committed potentially for the rest of his life.
But the choice here was different, which is he was going to be released in Massachusetts.
Well, you say
And
released
so-
in Massachusetts. I expect what you mean is that he
Right.
was going to be transferred to the parole. He was going to be supervised by parole here. Is that
The Massachusetts resident, he was going to be supervised
right?
here in
And
Massachusetts.
if he were not to be supervised in Massachusetts, you would say that.
And certainly here, Rhode Island was fully aware of Massachusetts' intent and could send him here for the other part of the statute here, which says that they can send people for treatment and for rehabilitation. So again, giving full faith and credit to Rhode Island.
But he was not being. That's during the course of his criminal imprisonment.
Well, and again, if
Are you saying that should apply to when his criminal imprisonment ends?
I'm
to
sorry,
a
I'm not
civil? Well, you basically say, yes, you can be transferred here for the purpose of rehabilitation.
Correct.
But isn't that during the course of one's criminal imprisonment, as opposed to what happens after one's release from criminal imprisonment?
Once he's here in Massachusetts, our statute has defined that he falls within that criteria. Any problems with with what Rhode Island did here is a Rhode Island issue that the defendant has to challenge in Rhode Island. So he's here legitimately in Massachusetts, and based on our statute, because he's a Massachusetts prisoner, we can file a petition against him because he comes within the broad criteria of the people that our legislature determined is entitled to treatment and rehabilitation. And it's on that basis that we filed this petition, and that we would ask that this court reverse the dismissal of this matter by the Superior Court judge.
All right, thank you.
Thank you.
Mr. Keneally, good morning.
Good morning. May it please the court, Your Honors, Joseph Keneally from Mr. Richard Gardner. Your Honors, I have to say I'm at a bit of a loss in terms of the facts here. The Commonwealth states that Mr. Gardner was a Massachusetts resident and he was going to be released in Massachusetts. Pursuant to the compact, particularly Article 4G, states any inmate confined pursuant shall be released within the territory of the sending state, which would be Rhode Island.
Do you know whether or not he agreed to go to Massachusetts?
If he agreed to go to remain in Massachusetts after the transfer, I know nothing.
Does he have to agree to the transfer, or did he agree to the transfer?
He did not agree to the transfer. He doesn't have to agree to the transfer. If you look
Okay,
at
that was a question. I didn't know that.
Supplemental Appendix, page 10, the form that was filled out by Rhode Island is called involuntary transfer.
Okay.
Okay, and I think that represents the standing of that. Section G states that any inmate confined pursuant to the compact shall be released within the territory of the sending state unless the inmate and the sending state and receiving state shall agree upon release in some other place. As far as I know, the record does not demonstrate that Mr. Gardner agreed that prior to his transfer to Massachusetts, he was going to stay in Massachusetts. In fact, the motion judge found in dismissing this case that, in fact, Mr. Gardner's intent was to go to Rhode Island and stay there with his fiancée, who lives in Rhode Island. Any notion that there was some sort of agreement by Mr. Gardner that he was going to stay in Massachusetts at the end of this, I don't think it's represented in the record. And in fact, it would be hard to imagine that he would agree, given the fact that prior to his date of release, there had already been a temporary commitment order issued against him, transferring him to the custody of the Massachusetts Treatment Center. I think that goes to the second issue involved here in terms of the compact, which the Chief Justice Gantz alluded to. I believe it's Section 4E, and that section states, let's get the page. The fact that of confinement in a receiving state shall not deprive any inmate so confined of any legal rights which said inmate would have if he had been confined in an appropriate institution in the sending state. That means Mr. Gardner cannot be deprived of any right, including the right to release, as is in any more than had he been in Rhode Island at the time. So according to the compact, absent a release from Mr. Gardner, of which there is none, he should have been returned to Rhode Island at the expiration of his probationary sentence, and he should have been released at that point. To do so, to fail to do so, would not only violate 4G, but it would also violate Article 4E, which says he can't be deprived of his rights. You cannot bring someone into Massachusetts and deprive him of the rights that he would have had in the sending state. That's a violation of the compact and is inappropriate. Now, as far as the notion that he was a prisoner in terms of the compact, I would submit to you that the compact, the New England Interstate Corrections Compact, exists to manage issues regarding institutions and prisoners who are serving sentences. Okay, this transfer was not to rehabilitate a prisoner. This transfer was to commit to the treatment center, potentially for life, an individual who was no longer going to be a prisoner. That's what this was about. It was not about a program of treatment that would end upon his release from criminal confinement. This was going to be a carryover sort of situation, where in fact what would happen is we get him to Massachusetts, now we have custody of him, now we can file a temporary commitment order, and then we can begin the process of committing him. So then, should he choose to, he could participate in treatment. No treatment was provided to Mr. Gardner after he was transferred to Massachusetts for that short interim. Any notion that this was done pursuant to the compact's desire to treat prisoners and inmates, I think is not exactly accurate, in that this was about beginning a process once his sentence actually ended.
So that was the involuntary part. The record would suggest that Rhode Island was on board with this, knew what was going to happen.
Pardon me?
The record would reflect that, would support the view that Rhode Island did send him there to Massachusetts for the purpose of his being subject to SDP proceedings, right?
Yeah, I believe that's what they were informed of, essentially, yes. I'm not saying that Rhode Island was correct in terms of the transfer. I'm not saying that Rhode Island was any less remiss in its reading of this compact than Massachusetts was. But the ultimate fact was, we have a situation where an inmate was transferred from Rhode Island to involuntary to Massachusetts. And the very next day that he was transferred, the petition was filed against him. This was obviously the Commonwealth's attempt to remedy the error. They had every legal right to petition against Mr. Gardner when he finished his Massachusetts sentence. They got the 6-month notice that was required by the Department of Correction that he was going to be released. They had every right to do it. And pursuant to the law, I mean, that process could have begun the minute they got the notice. They could have filed a petition against him, but they didn't do it.
Could Rhode Island have filed, do they have an equivalent statute?
They do not have an equivalent statute. So that would mean that if Article 4, Section E of the compact were to have been abided, then he would have been not subject to civil commitment, but for this transfer. And the Commonwealth is absolutely correct that the decision to transfer ultimately comes from the sending state. But this was based on the exertion of influence by the Plymouth County District Attorney's Office.
Well, putting aside for a moment the point about whether or not those concerns are concerns of Rhode Island or Massachusetts, unless I'm misunderstanding the Commonwealth's position, they seem to be saying that if somebody comes here via a compact, that they're a prisoner, which would expand the definition of prisoner to individuals who might not have that definition under Section 123A beforehand.
That's essentially my reading, Justice Lowy, as well.
And so I just want to go, because I think you cite to Commonwealth versus McLeod.
Yes.
And so if you were to take the Commonwealth's logic, if somebody was serving a sentence for a non-sexual offense in Rhode Island and then was sent here by the compact, then from the Commonwealth's view, they'd be a prisoner for the purposes of 123A, whereas if they were serving the sentence in Massachusetts, they wouldn't be.
I do not know under what definition pursuant to the compact, whether the regular interstate correction compact or the NAICC, someone becomes a dual prisoner. The compact is clear, saying that Rhode Island is in charge of this man, despite the fact that he is in Massachusetts. They make the decisions.
Yeah, my question's much more basic than that, and maybe I should have asked this of the Commonwealth, but the way I read the brief is that if you're a prisoner in Rhode Island, you get transferred under the compact, you're a prisoner in Massachusetts, which would mean that you might be subject to a petition, whereas if you were just in Massachusetts in that status, you wouldn't be, which obviously is an expansion of.
Yeah, and I think that there are all sorts of issues involving this as an expansion of the statute. I don't know how that game's out, actually, to be perfectly honest here. However, I do know that the compact states that this is a matter of jurisdiction, who has jurisdiction, and it's Rhode Island. This is a Rhode Island prisoner by every account, by every reading I've had of the New England Interstate Correction Compact. That's who it is. He was supposed to have been returned to Rhode Island. There's nothing to suggest that a temporary commitment order issued by a Superior Court judge in a 123A setting would entitle them to keep him here. He should have been sent back to Rhode Island. He was not coming back from Rhode Island, and he should not have been deprived of the right to return to Rhode Island pursuant to 4E. I would suggest, Your Honors, that this is yet another attempt to expand the statute, to expand the eligibility of those who are subject to civil commitment. Since 2002, there have been 6 attempts by the Commonwealth to redefine prisoner, to expand it, to include more individuals. This court has rejected all of those attempts. and so has the appeals court.
But what about Commonwealth versus Ballard?
Well, like I say, Commonwealth versus Ballard is the one exception to that. It's a 2018 case. It was decided 6-7 weeks ago, and it is still subject to further appellate review should this court see it. However, I would suggest that there has never been a case where the Commonwealth has been, where this court's been called upon to expand civil commitment to include people over which they do not have jurisdiction. This is the first such case. And this just goes back to what this court said in Commonwealth and Coffin versus the superintendent. This court said it will not expand the class of persons eligible for civil commitment under the statute without clear statement of legislative intent to do so.
Where, in your view, should we look to get a definition of prisoner?
Well, I think that what you can look at the case law that has defined the contours of this. I mean, you can look at McLeod, you can look at Commonwealth versus Gillis, the appeals court's decision in Allen. You can look at Commonwealth versus the Coffin case, Justice Gant's decision, the court's decision in Commonwealth versus Libby. And I think what you have to look at here is we know what a prisoner is not. We know a prisoner is not somebody who is awaiting trial pursuant to the statute. We know a prisoner is not someone whose sentence has expired. We know a prisoner is not someone who is still incarcerated on a conviction of a charge that was later determined to be unconstitutional, which is, I believe, the Coffin case. The issue here is when we look at what a prisoner is, all we have to determine is, does this mean a prisoner in the custody of Massachusetts or not? And if it's not, then we're expanding the statute. If it is, then we are restricting the statute. And since this is an issue of an individual's liberty, this man could be locked up for the rest of his life as a result of this. We have to construe these statutes narrowly. That's what this court has said time and time again. And I would submit that the adoption of the Commonwealth's position would enlarge the scope of the statute, so the government could seek to civilly commit anybody serving a sentence anywhere. It could be in Massachusetts or Rhode Island or California or anywhere. I would suggest that
If that's right, then 123A, Section 12A, which says where a defendant has ever been convicted of a sexual offense, the prison must notify the DA, then that would mean that a prison anywhere throughout the country would have to make that same notification.
yes, it would, Your Honor. And that's one of the problems I would submit with the Commonwealth's reading of the statute. I'd also point the court to Section 13B. Section 13B requires the agency with jurisdiction, which would essentially be the prison facility holding the individual, to provide prison documents regarding the individual to qualified examiners. Now, there's no way that the legislature could have intended a prison in New Mexico to be required to provide a qualified examiner in Massachusetts with documents regarding disciplinary reports or behavioral reports or something of that nature. We can't do it. And the issue is not that the legislature got this wrong. They just never intended for this to apply to this extent. The language is clear here. I mean, if you look at 12B, 12B refers to it states a prisoner or a youth in the custody of the Department of Youth Services. District Attorney's Office can petition against a prisoner or a youth in the custody of the Department of Youth Services. Now, the Commonwealth's position is, well, prisoner could mean any prisoner. It could be a prisoner in Minnesota. But they never speak to the other group in that clause, the youths in Department in DYS custody. And would that mean that only adults can be petitioned against in Minnesota, but we have to limit our petitions for youths to those who are in Massachusetts DYS custody? That would lead to an illogical result. And that's indication that that's not the point of the statute. In fact, if you look at that clause, the fact that prisoner is used in the same clause as youth in DYS custody, I think pretty clearly indicates that what the legislature was looking at was making 12B apply to prisoners who are in Massachusetts custody and not those who are in other states. So unless the court has more questions.
Okay, thank you.
Thank you.
And we'll take our morning break.